Hello everyone, Derek Johnson with Tatango.com. Today we're doing another TCPA case review with Joe Bowser from Innovista Law, home of the TCPA Defense Force. How you doing, Joe?
I'm doing well, Derek. How are you?
Can't complain. So Good. We have another case. This one is Edelsberg versus Vroom, V-R-O-O-M. And Vroom looks like an automotive company. So I'm going to read kind of the summary here of this case, and then you can fill me in if I'm missing anything, and then we can talk about, why this case was brought and what text message marketers can learn from this specific case.
Sounds great.
So let's go down here. This was July of 2016. So Edelsberg is a person. That's their last name. They posted a classified ad on Craigslist. So he was selling his mother's 2010 Toyota Prius. So he posted a Toyota Prius on Craigslist, and it looks like from the case notes I have here, he put his cell phone number in the ad. So he said, hey, give me a call if you want to buy this car. Here's my cell phone. I'm pretty ssure Craigslist says that's not the best idea, but who knows? That's up to him to do. So
that's South Florida.
Yeah, exactly. So, and then it looks like I'm scrolling through here. Okay, so 2 days later, a company called Vroom, V-R-O-O-M, they sent Mr. Edelsberg a single text message in response to his online advertisement, Craigslist ad. And that text message was sent to Mr. Edelsberg's phone, and it essentially said, hey, we are interested in buying your car, and if you would like to see our bid, or essentially our quote, click on this link, and if he would have clicked on the link, and I don't know if he did or not, it would go to a web page that would calculate kind of all the features and functionality of the car, and then essentially buy the car from him so he doesn't have to do this whole Craigslist type stuff. Is that pretty much kind of what's going on here?
Yeah, so he got one message. This case is about getting one message from Vroom, and the message said something like, hi, this is Scott from Vroom. We'd like to make an offer, but we need more information. Please provide it here. And then the link would have taken him to the Vroom website where he could have given more details about the car so that they could then make a real bona fide offer for the Prius.
Okay, and essentially these are the companies that then will maybe spruce up your car and then do a better job advertising it, and then they sell it to another person. So it takes all the work out of selling your car because you just get a cash offer from this company and it's done, rather than showing your car 10 times a day to random people from Craigslist. So there's definitely value there. So is this guy really that angry that he received one text message from Chris from Vroom?
I don't know that the plaintiff was necessarily angry, but he was represented by 4 different plaintiffs' firms. And it was a class action lawsuit.
Okay.
So,
and explain if I want to bring a lawsuit, let's say I got that text message, I want to sue Vroom. Why would I want to make it a class action lawsuit rather than just a regular lawsuit? Or why wouldn't I just take it to small claims court? Because I can take a TCPA claim to small claims court, right?
You can.
Okay.
Now, obviously, the defendant can remove the case to federal court. And the individual plaintiff doesn't have much incentive to bring it as a class action. If the case is successful and it settles, they may get us another small fee in addition to whatever damages the rest of the class gets for being the lead plaintiff, because they had to exchange documents, they had to get deposed. So it's not uncommon for the lead plaintiff to get some small additional payment for the time and trouble in being the class representative.
Class action lawsuit, right?
Correct.
But he's not doing the plaintiff is not doing all the work. It's mainly the plaintiff's attorneys. Those are the ones that have to depose people, come up with strategy. It's not like this person is like spending every waking hour thinking about this case, right? He's most likely he's most likely sitting at home working, and he gets a call when they need him or when it gets settled.
Right. So if you're driving around South Florida, you'll see billboards, there are websites. These plaintiffs' attorneys are looking for TCPA clients.
Okay.
So they make it very easy. If you get a call that you don't want, they make it very easy to find the attorney who will bring that case for you. And then, of course, they slap class action allegations on top of that to try to represent typically a nationwide class that has a similar set of fact patterns, facts for that lead plaintiff.
Okay, so in that kind of case, the plaintiff, this person, how much? Because one text message is anywhere from $500 to $1,500, depending on kind of what classification they can actually get for that specific text message, whether it was intentional or not. So let's just say it's $1,500. What is like the normal payout for like one of these people that call one of these people on a billboard and say, hey, I've been getting text message spam, compared to how much the attorneys make, on these? Like, I'm trying to figure out like, how does this ecosystem look? That's a fair question,
but the answer isn't fair.
Okay.
So the plaintiffs typically get anywhere from nothing to a coupon to, at the most, maybe a couple of $100s.
Okay, so you're saying the not the person, the main person in the case, the one that actually like triggered the lawsuit, not that person, but all the other people that join the lawsuit, they usually get kind of a few bucks, tossed their way. What about the person that, like, this guy that put his name on this lawsuit? How much money?
Well, so he would get the same thing that the class gets, right? So he's representing the class. So he would get whatever pittance the rest of the class gets, or up to a couple $100 perhaps. Yep. So he'd get whatever they get because he needs to be in class for purposes of the class certification rules. And then he may get an extra payment of a couple thousand, upwards of 10,000 if it's a very complex case and they put in a lot of time and effort. Okay, so he may get an extra payment, but you have to work for that.
Yeah, so he's not making millions of dollars unless maybe he's representing himself or something.
He can't bring a class action by himself because classes have to have competent class counsel.
Okay. So unless he was an attorney, he couldn't bring the case himself. And a class action lawsuit requires like a law firm. Like, it's not an easy thing to do. There's a lot of work, right?
There should be.
Okay. There should be. To actually win a class action lawsuit and take it. Okay. So, so it seems like I'm kind of doing the math in my head here. The people that make the most money, it seems like, are the plaintiff's attorneys.
Correct.
Okay, so the plaintiff's attorneys, they make a lot of money, but also they're spending a lot of time, presumably, on these cases. Then the person that brings the case, the person that slaps their name, onto this case, they will get the exact same thing that everybody else does that was harmed. And then they might get a little extra something on the side for...
it would get approved by the court, so it's not on the side.
So this isn't like backroom deals. This is like it's approved by the court, but it could be, $1,000 to like $10,000. They're not making millions.
Not at all. Not at all. No, the plaintiff's attorneys are the ones who are reaching for those 7-figure attorney's fee awards as part of the settlement kitty.
Okay, perfect. So now they've got all that kind of. So this was a class action lawsuit. So why do you have 4 plaintiff's attorneys? And you said law firms, like this was 4 law firms representing this guy?
Right.
Why do you have 4 law firms? Like they're just too small and they needed help, or why does that usually happen?
There are any number of reasons. That can be one of them. From a quick look, it did look like all of them were from South Florida, but sometimes, if the plaintiff happens to be from New England, the New England attorney will affiliate with someone from South Florida because you need a local attorney that practices in that particular court. So, depending on the geographic location of the attorneys, those guys can bind together. And then other times the plaintiff may have a personal relationship with an attorney. Some of these plaintiffs are professional plaintiffs, and they're a particular attorney that they may use with some regularity, wants a piece of the action, as it were. So they'll put their name on the suit, and then they fight over whatever they might win. In this case, nothing.
Okay. So sometimes there is cases where everybody kind of wants a piece of it. So there might be additional attorneys, but that's not a signal of a good case or not. It just could be a signal of just a lot of people wanting in on something.
This one is a loser.
Okay. I'll let you say that. So why was this a loser? What happened? Walk me through this guy. Let's hypothetically say he called a billboard, found an attorney, And he said, I've been harmed because I received one text message, which sounds kind of ridiculous. And now I could see if you receive 100 text messages, that's very annoying. And definitely, I think you have a case and it's, there's definitely some harm that has been done. But one text message seems a little ridiculous in my mind. It's frustrating, but not, it doesn't seem like it should require all this work and kind of hassle. So that's my personal opinion. So he contacted the attorney. The attorney said, great, this is a case that we would like. Maybe he brought in some of his friends. Then he said, I guess he filed the case and then they get the class certification. How does that work? Like, what is take me through the timeline?
Sure. So ordinarily, you'll need discovery to be able to get class certification, because one of the things the plaintiffs have to prove are the elements of the Rule 23 elements under the Federal Rules of Civil Procedure. So you need to show that this particular plaintiff's case will be substantially similar to everybody else in the class's case.
Okay.
So you basically need to show the judge that there is no point in having mini trials or individual cases for each of these class members, because the type of proof you're going to offer is the same for each one, such that you just essentially be repeating yourself and clogging the courts needlessly. So when we get, class cases on the defense side, we try to show that issues like consent are going to predominate in the type of proof that's going to be disputed at a trial. So if you can show that consent is going to be one of the key issues, and you have to look at everybody's facts individually, then class certification is not appropriate. So ordinarily, that class certification phase comes after some discovery.
Okay.
But from a defense strategy perspective, if this case is a loser, you want to get it kicked out as soon as possible. The first opportunity you have to do that is a motion to dismiss.
And that's after the lawsuit has been filed, right? Like,
correct.
They file the actual lawsuit with the court. And sometimes there's even like a demand letter, right? That comes sometimes even before the lawsuit, where it's like, hey, let's settle this, here's the lawsuit, but before we file it, there's an option to settle, sometimes. So it usually goes demand letter, then they file the lawsuit. So now we're at the point that the lawsuit has been submitted to the court, but at that point, is it a class action lawsuit or?
No, okay. It's a so-called putative class action.
So
the plaintiff wants it to be one,
okay,
and those allegations are out there, and they may or may not frame the scope of discovery depending on how the court structures the discovery process in that case. But it puts the defendant on notice that this plaintiff is trying to represent a class of people who are similarly situated.
Okay, so it's been filed with a kind of a warning, or essentially, or they're letting this company Vroom, they're saying, hey, FYI, we're going to try to establish a class.
Correct. Now that's something that the plaintiff has the burden of establishing.
Okay.
But at least the defendant is on notice that this case is not just about Mr. Edelsberg, right? It's
interesting.
Him and those who meet whatever the definition of the class is. Typically, it's a nationwide class going back 4 years of people who got the kind of message that the plaintiff got.
Okay. And it was interesting, you just said there that it's the plaintiff's responsibility to show that there are other people like this guy that were also harmed, right?
Correct.
And I've heard you say in previous case reviews that it's the defendant's responsibility for the TCPA stuff. Is that correct?
I think we need to get more subtle and nuanced there. What you may be thinking of is whether the defendant has to prove consent to get, to be able to make a particular call or send a particular message.
Yeah.
So consent is an affirmative defense under the TCPA, which means it's the defendant's job to prove that. Okay,
so that's like Vroom. They're the defendant. They have to actually prove. So a consumer can just come out of nowhere and say, hey, you send me text message spam, and it's not the plaintiff's responsibility, the person's responsibility to say, and here's all the evidence that makes me believe that. It's more on the defendant side, the business or brand, that says, hey, this guy's accusing you. You have to defend yourself now, and you have to show that you didn't do this. So it seems like a lot of onus is put on the brand, unfortunately, even if these lawsuits that don't have any, standing are filed against them, it still requires a lot of work on the brand side to defend themselves.
Correct. Yeah. So Vroom clearly here, because it was filed as a motion for summary judgment, which is a motion that you typically file after there's been some discovery in the case.
Okay.
So they filed a motion for summary judgment, which they won. And then the two key issues for the court were did Vroom have consent to send this message?
Okay.
And then if so, what was the level of consent that was required?
Okay, so
did they need prior express consent
Yep.
or prior express written consent?
Okay, so lawsuit filed, and then they did a little bit of discovery, which discovery is like asking questions and receiving documents and seeing records and kind of understanding more about what went on here.
Basically, yeah, it's essentially a cards on the table part of the case.
Okay.
So you do document requests, you do interrogatories, which are questions in lay terms, depositions, right? So where you sit down with a court reporter and the attorney asks the witnesses questions, and all of that's under oath and admissible in court. So yeah, so those are the typical discovery vehicles that you'll use.
So they did a little bit of that to kind of figure out, because usually the original case doesn't have much info in it about actually what happened. It was this person just said, hey, I received this text message from Vroom. Here it is. I don't know why I received it, where I received it from. That's where kind of the questions and the depositions, that's where they can get some of that info from. So
right.
Okay.
It's a rare case to win on a motion to dismiss. It's not unheard of.
Okay.
It's possible, but you essentially need the plaintiff to plead themselves out of court.
Okay.
Because on a motion to dismiss, the court has to essentially take everything that the plaintiff says in the complaint as true. And since a TCPA defendant has to prove consent, if consent is your key defense, like it was here for Vroom, you can't always just rely on the plaintiff's allegations, because obviously here, this plaintiff said, I didn't consent to get your messages, Vroom.
Okay, so after all that, then Vroom filed a motion to dismiss. Is that correct?
They filed a motion for summary judgment.
Okay.
The motion to dismiss is the one at the first stage of the case.
Okay.
Where you say,
This is
let's just
ridiculous.
pretend like everything you're saying is true.
Okay.
You still lose as a matter of law.
Okay.
Right? So fine. Everything you say is true in your complaint. Let's just pretend like it is. Judge, you still need to say I win, because they don't even what's called state a claim. Like these facts, if true, still can never cause the court to give the plaintiff a win.
So that's like a throw it out real quick. Like this is a very frivolous lawsuit, because everything here, if they say is true, that doesn't violate any laws. Like there's nothing here to even discuss going forward.
Right. So in the TCPA cases that we see win on a motion to dismiss, we've talked about one of those before, where the plaintiff alleges that they gave consent to a brand. We talked about that edible arrangements case.
Yep.
So that plaintiff alleged that they gave consent, and then they gave the allegations of how they allegedly revoked it. But because the court found that plaintiff didn't even revoke consent, the consent piece was already in the complaint. So the court didn't really need to look outside of the plaintiff's own allegations. But here,
and that's a motion to dismiss. That's kicking it out. If you don't do the motion to dismiss, then you do some kind of fact finding. And then you said it was a motion for
summary judgment.
Summary judgment. That's after there has been a little more info gathered. Is it kind of almost the same as motion to dismiss, but after you've kind of done some research a little more?
Well, it's the same idea insofar as you're asking the court to rule. What's different and what's important to distinguish in a motion for summary judgment is that there are facts on the table now that have come into the record from outside of the complaint. But what you need to prove to the court is that the facts that matter, the so-called material facts, aren't in dispute. And so plaintiffs might try to say, oh, there's this, metaphysical doubt about a particular fact. The court's not going to allow you to just throw things on the wall and say, aliens might have done that or something like that, right? But there are facts that are in front of the court that matter, that weren't in the complaint, but are now admissible evidence, and they're not in dispute. So basically what you're telling the court is, hey, court, we don't need a trial because what juries do is decide the facts. But because the facts aren't disputed, here are the facts, and now you get to tell us who wins as a matter of law. And since Vroom was saying I win as a matter of law, they filed a motion for summary judgment. And clearly in this case, the court agreed with Vroom that the facts that matter aren't in dispute. And sure, they can come from outside the complaint, but let's take it as true that these are the facts that matter. And in light of this record, there is no reasonable juror who could do anything but say that Vroom wins as a matter of law.
And you say they come together and they say that both things, like, yes, this person received a text message that is Edelsberg says that he received a text message, and Vroom said, yes, they sent the text message. Everybody agrees that this was what happened. So that's kind of where they get to at that stage. But then they say, based on there's no debate anymore about like what happened. Everybody's on the same page. Then they can say, well, based on being everybody on the same page with all the facts on the table, this is not a case. This, based on the law, this is not a case.
Correct. Right. Because it's the judge's job to apply the law. So if you so the judge's job is to apply the law to the undisputed facts. So if the facts that matter aren't disputed, it's now ripe for the judge to make a legal decision.
Okay.
Right? It's time to call balls or strikes.
Yeah.
Now, in this case, it turns out that the plaintiff argued that they should get more discovery because they wanted, more information about some issues that the court agreed were independent and collateral of the facts that matter.
And the plaintiff is this person, right?
Correct, Edelsberg.
So they're just trying to cause more work for Vroom and for racking up attorney fees, because Vroom has to defend themselves no matter what, they throw at them.
Right. It's always there's always a judgment call from the defendant's perspective about when you file that summary judgment motion. In this case, it looks like they filed it relatively early, and we will often do that. But the risk, and we've talked about one in the Seventh Circuit that came out recently. The Seventh Circuit ruled that the trial court granted summary judgment to the defendant too soon, because the plaintiff didn't have an adequate opportunity to get the kind of discovery that he might need to test the defendant's story.
So it's a lot of strategy and kind of, inside baseball that's going on here. It's not as cut as dry, as you see on TV usually.
Right. So sometimes the defendant's perspective is, let's make this difficult. Let's make these guys work. Right.
Because they might then settle, right? Because they'll look at it and go, this is going to be a 6-month thing. Maybe there's a cash settlement that we could just pay him to go away.
Correct. But if you want to get the win, right, like Vroom has an incentive to get a published decision that validates its business practice. Right. That's not worthless.
That's interesting. So there's value in actually winning a TCPA case other than just not being sued, like losing $1 billion, essentially. Like,
correct. I mean, it's one of the things that we talk about with our clients. Sure, you can often get a nuisance value settlement, but what's the value to the company of getting a published decision that validates your business practice? And some clients say that it's in our interest to spend commit the resources necessary so that we minimize this risk going forward, right? We're testing this model out. We want to deploy it, but before we really leverage it fully, let's use this as a test case before our exposure is 10x, 100x, and really roll out this campaign. So some defendants will rationally choose to go and test the waters. Because once you get a win, the plaintiff's attorneys will be reluctant to try again, right?
Yeah, and that's what I was going to say. So if Vroom continues this process and maybe they take it to a different scale, it would be very unlikely, if they're doing exactly the same thing, another attorney to be like, ooh, there's money to be made here. Most likely not, because they look at it and they go, well, some other people have already tried this and it's been thrown out. Maybe let's go find other things to, find.
I don't know about very unlikely. I mean, plaintiff's attorneys,
they'll try.
You can't control them. Yeah. They're going to sue who they want to sue, but it's certainly a very good weapon to have in your arsenal.
Do you see that very much, like a case like this, and then they'll try again, or like is that sure. Okay? So it is common, but it's not. It does help a business.
It often depends on the kind of defendant, right? So
Okay.
financial institutions will be repeat litigants because there are often other claims in addition to the TCPA claims, right? So
Okay.
banks, for example, will get Fair Debt Collection Practices Act claims, FCRA claims, the Fair Credit Reporting Act claims, and then they'll throw the TCPA stuff in there as well. So Vroom is probably really only exposed on the TCPA side for this kind of business practice.
Like it's a narrow use case. It's one little thing that they're texting out. They're not texting out like HIPAA compliant type stuff or debt collection. So it is very unlikely that attorneys would keep trying, to sue Vroom under this specific use case.
Right. Bank of America is probably still going to call people when you don't pay your bills.
Yeah. Yeah.
Right. Like they're going to keep calling people. But Vroom, they want to get this practice validated. And so there is some value to them, I'm sure, in getting a court to say, no, like what you're doing doesn't violate the TCPA.
Yep. You're good to go. Keep doing what you're doing.
Now, this is obviously this is one trial court until the Supreme Court rules on something. It's really not the law of the land. So it's good as far as it goes.
And
right?
Explain that difference there. Are you saying that like wherever they're located, Vroom, it might not be okay, or there might be, a different rule of law in another state or a different part of the country until it goes to the Supreme Court, then it blankets everything.
Correct. So, this case came out of the Southern District of Florida.
Okay.
Frankly, this court can change its mind on similar facts, right? Another judge, I'm not saying this was a close case, but another judge could do it, could go a different direction.
Okay.
A part of this case, and we may get there later in this episode, this particular message was a so-called dual purpose message. Was it an informational message and a telemarketing message, right? And this is an area of TCPA law that is fairly gray. So you can definitely find judges that have different opinions on where that line falls between informational on the one hand and promotional on the other. So now if this case got appealed to the 11th Circuit, which is the appellate court that would oversee this particular trial court, if they affirmed, then that would be the law of the land for that circuit. But you could probably find another circuit that might come out a different direction.
And a circuit is like a different area of the country, right?
Correct.
Okay,
correct.
So it's like over here, they've made a decision.
You're in the 9th Circuit in Seattle.
Okay.
This is in the 11th Circuit here in the Southeast.
Okay, so again, and this is just how crazy that I think the TCPA is it's not cut and dry all the time. Like I think people think you put, all you have to do is just put a few disclosures on your website when you're opting people in. The TCPA can really vary, or the way that the courts interpret it, based on where you're located.
It can.
Wow.
It can, right.
Okay.
So the outcomes can be rather different based on which judge gets the case, which court gets the case. So we, for example, when we're preparing contracts for our clients, we'll often make choice of law selections that speak to these issues so that if we go to arbitration or we go to court, we feel like we're positioning our clients in the best possible framework, from the TCPA perspective.
So if that client, let's say, has 40 different, headquarter locations all through the United States, you might look at each individual state and say, well, if somebody, agrees and consents to receive text messages, we're going to make them or try to make them agree to consent and arbitration or, kind of going to court in a certain place.
Well, the location is one thing, but the choice of law is the other. So location is more forum oriented, and that, that can be wherever the client is based, whatever. But the choice of law is, so you can have an arbitration in Texas, but you can tell the arbitrator, we want you to apply New York law, for example.
Oh, okay. I didn't even know that.
So the Texas arbitrator can apply New York law. And then you can also say, but if the claim arises out of or relates to the TCPA, we want you to apply 9th Circuit and 2nd Circuit case law and not 11th Circuit case law, because the 11th Circuit has some TCPA law that's not terribly helpful for callers, at least as it relates to revocation of consent and some other issues.
Man, it feels like I'm always getting like a legal education whenever I talk to you. And I think this goes to the point that the TCPA is complex. It is not something that, a software provider or even Vroom should try to figure out themselves, or a brand. It always requires a third party, a TCPA attorney, to really look at it and go through all of this stuff. It is not just, okay, we're doing a double opt-in. It's where are you doing the double opt-in, the law, the location, all of these things come into play. Now, for this specific example, how were they able to get it not dismissed, right? It's, what was the term?
The case was dismissed.
Okay. That's just a general, okay.
The vernacular is a little confusing
so
sometimes. The case was dismissed.
There was two things that the judge said, well, based on the law, this doesn't have any merit. It shouldn't go to the jury. So what were those two things? And then what were those two things and how those apply to text message marketers? Like, how can they use them, or what significance does it have?
Sure. So in this case, the first key question was, what was the level of consent that Vroom needed to have to be able to send this particular message, right?
Okay.
And so that required the court to look at what was the purpose of the message. And the purpose of the message here was to make an offer to Mr. Edelsberg. So he was saying, oh, you're a business, right? At the end of the day, you want to sell stuff. You want to sell cars. And Vroom said, fair point, but that's not why I texted you. I texted you so you could give me information so that I could make you an offer to buy your car.
Because in the Craigslist ad, I bet he said, call me to make an offer. So they were kind of following his instructions almost. Is that what you're saying?
Exactly. And so he was deposed, and he admitted in his deposition that if Vroom had offered top dollar, he would have been fine to sell Vroom his car.
So it literally is just like me text messaging him and I would, because I don't like calling people. I'd be like, hey, I'm interested, in your car. So he thought there might be maybe some money or something behind the fact that it was a business that did it. And maybe he saw one of these billboards, that these TCPA attorneys put up. So he thought maybe there was, because it almost seems like you wouldn't even be angry at somebody text messaging you, giving you an offer for your car. Even if it was not a good offer, I would say, well, okay, whatever, and move on.
Right. So he didn't get an offer per se, right?
Okay.
They sent him a link to the website because they wanted more information, right?
Okay.
His Craigslist ad apparently wasn't terribly illuminating. It said it was a clean car and it had so many miles. Maybe they wanted to know what trim it was. I don't have a Prius, but obviously there are details about any car that any purchaser might want to know about, right?
Okay. So maybe he was frustrated.
Past accidents? Who knows?
Yeah. Okay. So he was frustrated maybe because he was like, this is a business text message me. They really don't have an offer yet. I had to click on the link and fill out all this stuff. So, and he looks at $500 to $1,500 per text message. And he says, oh, interesting. But the court, they said that it was. They said that
he gave them
the consent
to text.
Because
that particular text.
And he didn't do it like personally. He did it in the Craigslist ad. That was his consent.
Right, because the FCC has long held for about 15 years that when you make your number available for a particular commercial purpose, you're giving prior express consent for the business to contact you about that area of business. Right. So if you give your number to the bank, the bank can call you about bank business. Now, they probably shouldn't call you to sell ice cream or vacations. Yeah. But they can call you. They have permission to call you about the purpose for which you gave them your number.
It's just weird in this case because he didn't give his phone number to Vroom. He gave the consent essentially to the entire internet to call him about his car, and one of those people were Vroom.
Right, and that is an important caveat about this case. The court did note that he didn't put any qualifiers on his phone number, on the use of his phone number.
Okay, yeah.
So there have been other cases where, for whatever reason, and it's fine, someone put out their phone number but said, "Don't text me."
Oh, interesting. Okay.
So if a bot was just trolling Craigslist and they vacuumed up that number and it didn't also take in the narrative portion of the ad that said, "But don't text me," this case might have been different.
Interesting.
Right?
Yeah.
But since this particular ad didn't have any conditions on the use of his phone number, the court felt comfortable saying this fits neatly within how the FCC has construed prior express consent for non-promotional text messages and phone calls.
Was it ruled? Was it ruled or agreed upon that this was non-promotional, or was that still up in that wasn't decided?
It was ruled that way because if it went the other way, if it was found to be dual purpose or a marketing message, then Vroom would have needed to prove that it did have prior express written consent with all of the, the disclaimers and the terms that come with that.
So this message was found to be informational, even though it was kind of marketing and sales, but it was informational because it was he asked for the offer and they gave him the offer essentially. Like that's informational.
They were making an inquiry to get more information from him to make him an offer.
Okay.
They weren't trying to sell anything. They were trying to buy something.
Okay. Interesting.
Right? So they were buy side on the transaction. And so that was hugely important to the court. Like for the court to be able to make that dual purpose analysis, it had to find that the point of this message was just to get information. Now, granted, the court acknowledged that Vroom is in the business of buying and selling things, but this message, read fairly, was just soliciting more details from the seller so that they could make an offer.
Just like I would do if I texted the guy.
Correct.
Yeah. Okay. So
right. Hey, has this car ever been in an accident? If you send him that text, you wouldn't expect to get sued for it.
So
right?
let's play this out. Let's say it was Auto Trader, and Auto Trader found his phone number on the web and it said, "Hey guys, make me an offer, text me," or whatever. If Auto Trader sent him a text message that said, "Hey, you should also list your car on Auto Trader. We get really good, results and stuff like that. Here's a link." That would be most likely marketing because it's not informational. It's not responding to what he's looking for, essentially.
I mean, that's a different analysis, right? Because
it's different than what he was asking for. That's like it feels to me like a very marketing focused thing because it's pitching your services, not that you're making an offer.
Yeah, I mean, the fact that a business tries to make money can't make every message a business sends dual purpose.
Okay.
Right? Even nonprofits can generate revenue, right?
Yep.
So the fact that an entity generates revenue in the ordinary course of business can't make every message a marketing or a dual purpose message. Otherwise,
just because it's from
point.
the business. Yeah, like
Right.
It's not a blanket statement. If you get a message from a business, it's 100% marketing. You never can argue that. That's not true. It could be informational.
Right. So exactly. The context matters. And, really the standard does look to the intent of the message. So here, the court did, study the substance of the message closely and felt comfortable concluding that while Vroom, may make revenue by selling this car down the road, that's not why they were writing him. They wanted to buy it.
Interesting.
Maybe the owner wanted to drive it around, Maybe it was going to be a model. Who knows?
Yeah.
But this particular message was soliciting information from the consumer to be able to make an offer.
So this seems kind of like a very, very narrow use case. What can we learn, like on the macro, from this case for text message marketing or integrating SMS into a sales process? Is there anything like big level, because obviously this specific, if somebody's selling their car and you buy cars, you now most likely can text message them. There's still risks, obviously, but it's been decided here. On a more macro level, is there anything we can take away from this case?
Well, I think it helps just put another marker, in the field of play about where messages fall on that spectrum between informational on the one hand, dual purpose in the middle, and then promotional on the end. And I think it just should train people to be sensitive to the importance of analyzing each particular campaign and not just setting it and forgetting it and saying, we thought about this once, let's just run with it. So if you're going to make changes to the verbiage, that TCPA light bulb needs to go off in your head and say, hey, am I pushing this closer to the dual purpose side of the line? Is this something that I want to run by the compliance folks, the legal folks, outside counsel, et cetera, to get, a more nuanced analysis of a changing campaign?
So it's interesting. So essentially, if you are a business, it is not cut and dry that, it's always marketing your message. It could be dual purpose, or it could be informational. Like, just because you're a business doesn't mean it is only one thing and always one thing.
No. And, we've talked about some of these mixed use cases before. There's a famous one from the Ninth Circuit out where you are, where Best Buy sent text messages to the people in its reward program saying, hey, your points are going to expire. Mm-hmm. Well, the people in the marketing department probably thought, well, I'm just letting them know the information that their points are about to expire. But both courts found that no. Best Buy really wants you to come into the store and buy more things. Okay. Right? That the point of sending that message was, hey, sure, your points are about to expire, but odds are you are going to overspend, and that is going to hit the company's bottom line in a positive way.
That was found as a marketing message? It was determined that was a marketing message.
A dual purpose, which makes it marketing, right? So if it's dual purpose, you've got to hit that higher level of consent.
So, and I know the answer to this, but I'm going to ask it just to make sure. It's always better to come up with a concept for what you want to do and then go to a TCPA attorney like yourself, discuss these things and discuss strategy, change things, look at where you're sending, where you're not sending, things of that nature. Before, it seems like a lot of these cases, you go to a TCPA attorney when you get a lawsuit like this.
That is a suboptimal time to have the discussion.
Okay, so always, and why do you think people don't go to a TCPA attorney before? Do they think it's just going to be expensive, or they're going to limit the amount of stuff they can do and kind of be a pain in the ass? Like, or am I just making that up? I don't know. It seems like a lot of these cases, TCPA attorneys always get brought in at the end, which is never good. Is there any advice, or like, is it not that crazy of a process to do it up front?
Well, no. We have a lot of clients who come through, and we work on mock-ups, and we architect the flow with the marketing team and compliance folks, and it doesn't take a lot of time in the ordinary course. And oftentimes they run off, and we don't hear from them because it was architected correctly. Okay,
so you're not trying to
it is normal that we get these questions. Yeah,
you're not trying to stifle innovation all the time. Like, I feel like maybe people are just afraid to go sometimes to legal compliance because they're like, oh, this is just going to ruin my entire campaign. You actually like help people figure out the objective and the strategy and how to get there legally. Not your job to just axe everything out and say, there's no way you can do any of this.
Well, no, we want our clients to have a positive customer engagement strategy, one that, respects the customer's privacy, gives them a good user experience, and frankly, complying with the TCPA, fits with those goals. Like if you're sending unwanted messages, you may be injuring your brand. So that's probably not good in the long run. Obviously, the expense of a TCPA lawsuit is not good for the company's bottom line. And, it's the old ounce of prevention rule. It's just something that makes sense on the front end. Does it add a little bit of cost on the front end? Probably. Yeah. Is it material? Often not. And, we're not no people because there's almost always a way to do it. So we're not no people. We do yes if, right? And so we just steer people in the right direction. And it's rare that people come to us with ideas that can't be repositioned in a way that complies with the TCPA.
Yeah, I've seen that before. It's a lot of repositioning, tweaking things. It's most of the time, except you come to like, I've heard people come where they're like, we bought this list of phone numbers. Like, then that's obviously no, there's no way to tweak that. That is definitely spam. But for text message marketing,
typically.
It's interesting too that you brought up here the hurting of the brand. I think this is something on my side that a lot of text message marketers forget, is that, again, you can go to the TCPA Defense Force, Innovista Law. They can sign off on it like maybe you guys would have done with Vroom or something along those lines. Mm-hmm. But also, I think text message marketers have to also think, how is this going to impact my brand just from perception? if the court says this is not spam, that still doesn't mean consumers are not frustrated with you or angry about what you're doing. Or you could even learn from this and maybe put, maybe make offers, on the cars in the text message. Maybe that would reduce some of the frustration. Just because a court says it's legal to do, sometimes it could hurt your brand from just a consumer perspective. I might not want to do business with Vroom if they send me these messages. So and I would do the same if they called me because I don't like being called. So there's there's multifacets, I think, to text messaging. There's legal, there's obviously software platform, the technology, but then there's like common sense and your brand. So I think all of those things, and that's why I think we work really well with you guys and other TCPA attorneys, because I think we all come together in addition to the brand and we say, how can we get this done, but excite consumers, make them feel real good, make them feel like they're not being spammed, even if it is legal. You guys make sure it's compliant. We make sure it's CTIA and carrier compliant, plus we bring the technology. It's not like a one, track kind of process. It includes a lot of people.
Right. Yeah. When we do these kinds of projects, the audits and the workflow projects, we're always working with the marketing teams, the compliance folks, in-house counsel. So it's a multi-stakeholder process because you want everybody to be bringing their expertise to bear, and we almost invariably get a better product.
Yeah, I agree. I 100% agree with that. Well, again, great TCPA case review. Anything else to add? I know we've kind of talked about everything, and I feel like I'm always getting a legal education. I should have paid for this rather than my college.
I think we nailed it.
Okay, perfect. So this was a TCPA case review, Edelsberg versus Vroom. Again, my name is Derek Johnson with Tatango.com, and I'm with Joe Bowser, a TCPA attorney from Innovista Law, home of the TCPA Defense Force. Joe, what's your website? Because I know you have a bunch of good stuff there.
Yeah, it's tcpadefenseforce.com. No tricks. tcpadefenseforce.com.
Awesome. Check out their blog. They're always up to date in their guides, webinars, training video. They have a lot of content, so definitely worth it. We'll link it up in the video below. Again, thanks everybody for watching, and Joe, thank you for your time.
My pleasure. Thanks, everyone.
Thanks.